commercial contracts, and nice things that accountants refer when they've sat down with their clients and said, you need a shareholders agreement. It would be beneficial if you had different types of shares, options, share schemes, and things like that. So very varied amount of work and scope of work. But enough about that. If you have something like that, just give me a call and we can find out if it's something that fits in what we do. Questions are great. We'll try and answer them at the end. There is a point in this webinar where I will want you to use the chat box, and just that's to say I like something on the checklist, which we'll put in the chat box at the relevant time. And I want to know a bit more because I'm not going to be able to go through everything in detail, and there might be some burning question that you'd like me to go through and think of a scenario for and explain in more detail. So that will come through and we'll prompt you at that time. So if I haven't managed to answer a question, then just get in touch and we'll be very pleased to help you. General about what HR and employment law is, but you'll get these slides if you request them and you can have a look at that in more detail. So wanted to spend a few slides going over the basics of, I've just had a power off notice. Can you still hear? Okay. That's cool. Anyone, if there's a problem, let me know. So with directors, with the company structure, especially in small businesses, these three roles of directors, shareholders, and being an employee of your own company can get rather merged. And we do find that, particularly in small companies, all the people involved hold all those roles and have all those hats on. But as a company develops, the management and the ownership can get a bit more disjointed, but it is worthwhile just bringing to your attention who does what in a company and why. So directors really do manage the day-to-day decisions and don't have to go to shareholders for too much, really, only where Companies Act directs it, or there's something in the shareholders agreement, and we'll find out more about that later, that asks them to get shareholder buy-in on something. The shareholders hold the shares and they don't run it. And employees provide the services for the company in return for salary. It's important that termination of each of those roles is done separately and not in, if it happens, done separately and not just as a you've gone as one role and therefore you must go as another, but equally also appointment of in those roles does need its own setup and paperwork. Sometimes it'd be really obvious what you need to do for that. Other times you might think, well, I'm a director, do I need a contract of employment and things like that? We can help with that if those are considerations that you've got. What I do find, just worth saying, is that directors who hold a majority of shares forget that when they go into a directors meeting, they only have one vote in that directors meeting, rather than the number of votes that their shareholding might give them. And that can sometimes shift the power and the perception and lead to some wranglings going on. So just remember your role, what hat you've got on at a particular time, and try and act accordingly. Companies are made up of your articles of association that you set up when you incorporated the company, or a company is incorporated, and they link to the Companies Act. We've had a few. At the moment, the model articles of association are linked to the Companies Act 2006. But when I get instructions, I delve back into the articles filed at Companies House, and we can find that they're from 1985, in which case we've got to get a big red book out and look at what Table A says about that, and sometimes older. It goes without saying, really, that it's quite a good idea to have your articles linked to the current case, to the current legislation. But also, did you remember? Can you remember what you incorporated with? Were they model articles? Were they a bit bespoke with some preemption rights in or little tweaks? Are they in line with the current acts? And have you ever looked at them again? Did you look at them at the time, or were you did someone help you incorporate the company and just put a set in place to comply with that requirement? And you start doing things with shares. That's the first place we look to see what's in place, what do you have, and start to get those in place and think about how does that now work with the setup that you've got with the company as it's evolving. Basic articles, the model articles, are really good at when there's a small number of shareholders, small number of directors, but equally when the management and the ownership is held separately. And we all know that's not really what happens in smaller companies, and particularly family companies. Everybody has those different hats on, as I said before in the previous slide. They deal with operational things like votes, meetings, a complicated clause on conflict of interest about having to declare that and then get consent if there is a conflict, which I have to say most companies don't know exists and are probably in breach of most of the time. Doesn't deal with transfers of shares other than to say the directors can refuse a transfer subject to reasonableness, but there's no rules and no valuation procedures. And then it deals with loads of lovely things such as liens, seals, proxy votes, alternate directors and things like that, which aren't really the nuts and bolts of what shareholders and directors are looking to protect. And that's why we think about having a shareholders agreement in addition to the articles. Other word to note is as soon as you've started adding more share classes to your company, the model articles are out of date because articles should set out the share rights for all classes. Again, something that's potentially forgotten. Bit of a hobby horse this, but a quick note about statutory registers. It is a legal requirement to have them. And I often find when I'm starting to help a business exit and think about its due diligence, that we go, oh, where's the share registers? And they're either in a nice lever arch folder and not been updated since the company started. Sometimes they're brilliant, updated, all done, dusted, kept up to date, or they never exist. So it's a starting point for due diligence, but it is a breach of a statutory duty for a director not to have accurate registers at all times. Yes, a frightening unlimited fine there, but you know, that's what the Companies Act says. Remember that Companies House has a great filing side, and you can look at a company and find out all sorts about it just at the click of a button if the website is working. But that's just a snapshot of what is happening at that time. If there has been a share transfer before in the period between one annual return of CSO1 and another, then that won't show until the next one, and you'll only know that who has some power in the company by a change in the persons of significant control. But this isn't a webinar on company secretarial work, so I'll leave it at that for now. But just think, where are yours? Are they up to date? Do you need some help sorting them out? for your statutory registers. When businesses are set up, people normally head for ordinary shares of £1 each, but it could be a penny, it could be 10p, and give them these standard rights of 1 vote per share. If a dividend is declared and there's 10 shares in issue, then each share gets a tenth of that dividend. And if the shareholders want to sell the company or it's wound up, then the money in the company gets divided by the number of shares in issue. That's the standard. And for many times that can work okay until the company starts to evolve, shares start changing hands, people are added as shareholders who have different responsibilities in the company. You start giving shares to employees, all things like that, and potentially what you discuss with your accountant as, oh, you'd be better if you set up alphabet shares because there could be some tax benefits. I'll leave the tax benefit aspect to your accountant because we don't give that advice, but we do put those schemes in place with the help of accountants. Just a note here that any transfer of shares does need some process, like the bare minimum a stock transfer form, even if the share is being sold for no money, zero consideration. Solicitors also like to look for board minutes to approve the share transfer by the company. And we'd ask at that time, yes, we can see the articles, but do you have a shareholders agreement? Depending on the age of the company, I can be met with a few different answers. Yes, but it was never signed. Yes, we do. Here it is. I can't remember. Maybe we do. So it's in trying to say the agreement's necessary or a benefit to you, I can say it's not always looked at, but when it is, and when something happens, it can be worth its weight in gold. And that's the decision that a group of shareholders and directors need to consider as to whether it works for them to have that agreement. So that's standard. And then introducing some more fancy shares that you might have heard about and seen. And the list it can be anything. You can get quite creative, really. You could have an A share that's just got a dividend. Sometimes accountants will say that it should also have a capital right to achieve its purpose. You could have non-voting shares and preference shares, potentially, if an investor wants to get their money back before any dividend is declared. There's also some fancier ones, which are used often for share incentives. You could do a whole seminar on each of these. I just want to introduce the idea that ordinary shares is what works for some, and then a company grows and needs other things. And there may be tax consequences and tax incentives and tax benefits as to why those steps are taken. So modifying share rights is something that I see done well, done badly. When we do our little look into what's happened for a company at Companies House when we turn detective, sometimes the first you can see in a company that anything's happened is just that share rights or ownership has changed on a annual return, a CSO1. But really there should be an impetus at that time, if you're going to be changing share rights, to think about what documentation that you need that would stand up if you sell the business or there's some due diligence by a lender or a buyer. And it also helps with the valuation. If something's done right, then it can keep the value of your company because people trust that you've been running it correctly. Um, it also is a time to think about whether articles that you've got fit and whether it now is the time to have a shareholders agreement or some other scheme document if you've got other shares in place, or potentially going to have some options or enterprise management incentive shares, EMI. Um, so there's points of time in a company's setup that mean, yeah, I think I need to look back at what we did in those heady days of setting up when we were keen to just get a company, open a bank account, appoint us an accountant, and we'd parked the idea of anything more fancy at that time due to monetary restraints, time, energy, all those things. And as a company evolves, there becomes a time to just to think, are we a bit more of a sophisticated entity now that we need just to have a look and see if everything's still working for us? Um, yeah, I wanted to just give a reminder here that steps are important. Talked about share transfers needing a stock transfer form, even if no money's changing hands. Consider if you've actually paid the stamp duty that's needed, if money is changing hands for those shares, because that would be a problem in due diligence again. The fines aren't too huge, but again, it just kind of makes sure that everything's been done right. Allotments of new shares, creation of new shares. There's company secretarial paperwork that needs more than a nod to, and potentially if a company is buying back its shares so that they're coming to cancellation, aside from getting HMRC clearance, which is what an accountant would help you with, if the process is not done correctly, it's actually void. And so a company may have paid money to have some shares back from a shareholder that's leaving, but it's as if it never happened if the paperwork's not right. And I have had to unpick a few in the past, which is a bit tricky when the person who the company bought the shares from, has danced into the horizon with the cash. So worthwhile thinking about what Companies Act requires you to do, and for the sake of a few bits of paper and filing bits and bobs, get it done right. So the company's evolving. It started with the founders. It might be a family company with mum and dad, and then people join, other members of the family or managers get brought into the family fold, and people start to want to give shares to employees. And we do talk about quite a lot from the employment side of the business when there's thinking about how to incentivize employees when it's potentially hard to pay more salary, how to keep people involved in the company and not wish to go and work elsewhere if they feel like they've got some ownership in it. I'm not going to go through all of these because we only have a short amount of time, and I want to get to the nitty-gritty of what clauses that would work for you and in different scenarios. So we'll concentrate on founders and family and employees. Founders are an interesting beast because they have set up a company. As I said before, you've got the energy of thinking of your idea, getting the bank account, getting an accountant, doing this, that, setting up for VAT, setting up for payroll. And you breathe a sigh of relief. Right, I've got a company, it's got some articles. What do I need next? And it's although advisors from both accountancy and legal will say, if there's more than two of you as shareholders, we recommend a shareholders agreement. But, I do appreciate at that time that, we won't fall out. We'll never sell our shares to anyone else. We'll always agree on what's best for the company. And if we don't agree, we'll just not take that route. That's fine. And it can work. And I'm not meaning to scaremonger, but let's just, the next when we go through the scenarios, we can see that that's not always the case. And by having something in addition to the model articles could save the bacon. As a company changes over time and its value accrues, then that's time to think about refresh of the articles. Are they still working for you? And are the benefits to a shareholders agreement? And it can help to regulate the trust amongst the parties. But it's a tricky thing to negotiate even at that time. I'm not going to gloss over that. Families, family businesses like to think that everyone's involved, but mum and dad might, if they're the founders of it, may feel that they've got more sway and they can direct their shareholding children and spouses to not do or do certain things. But companies law doesn't work like that. It doesn't have special laws for family shareholders. That is only because of the degree of trust that is within those parties. And as soon as the net gets wider for who is involved in the company, then those links can get weaker, and it's time to think about, do I still have the control I want, or am I going to find that cousin Tom has sold his shares to a rival or invited someone that we don't want to be in our family business to be a shareholder? And that can be the same for founders as well. The control of transfer of shares isn't governed by the articles. And then there are employees. Well, they've probably got their shares because you wanted to incentivize them, as I said. You've gifted them. They had the chance to buy them under an option, or you've set up some scheme that's tax efficient for them to obtain the shares as a result of performance under the EMI scheme, because there's authorised and unauthorised schemes for tax purposes, and an EMI one is really good for that if it works for you, because it covers off the fact that the gain in the shares is not taxed as income tax, but as capital gains, which is obviously a benefit to that employee. All of these come with a health warning of tax. And if you did ring up wanting to give shares to an employee, I would be saying, have you spoken to your accountant before we went much further, because there's just a little bit more to consider. But, they got those shares. It's an incentive to stay. But if they do leave, what do you want to happen to those shares? And do you want them to have a vote? Things like that need considering. And that's when scheme documents and a shareholders agreement for employees comes in handy. But it could be that you just put some provisions in the articles to cover this off, and we can get to the pros and cons of that in a moment. So, getting nearer to the shareholders agreement, I do recommend that it would always be, if you have a shareholders agreement, your articles will stay in place, but they may be amended in certain aspects to update regarding new share classes, or just to make some nicer provisions about conflict of interest so that you've not got to get conflict resolutions. But I wanted to set out here the usual differences. So articles are binding on a shareholder when they take their shares. They don't have to do anything else. Those are the rules that sit there, but they can be amended by special resolution. They're in the public domain. So you wouldn't want to be putting secret things in, or things that you just didn't want competitors to know about. And that's a consideration. And as I've mentioned before, the model articles that would be there if you didn't have any bespoke ones, tinkerings to the model articles, or could be really old ones, have limited provisions, and unless they have been sorted out and made a little bit more a bit more helpful. I do see a bespoke sets of articles that are simple and have some provisions in. So, it can work to have all these nice protections or some of the protections in articles, but it's normally the public element, the fact that it's available on the website of Companies House that makes people think, oh, well, actually, let's just update the articles so that they work for us now and put all the more confidential, more business specific aspects in a shareholders agreement where we can be a bit more flexible about what kind of thing is included there. And it can mean that a company can be bound to do or not do some of the provisions which isn't the case in articles. And it becomes a contract between the parties rather than the shareholders relying on Companies Act restitution or procedures if they feel that they have been unfairly treated. It is worth mentioning about shareholders and minority shareholders. With just articles in place, they don't really have a market for their shares, and that can really mean that if they are disgruntled and they don't want to pursue an unfair prejudice action, which speaks of having to go to court and things like that, if they feel that the company's not being run in their interest, they haven't got a way of selling their shares. But having a shareholders agreement can really help all shareholders have a market for their shares, i.e. each other, in particular minority shareholders who if they're not a director or one of many directors, don't really have a say in the company and can find that maybe they're not getting the dividend that they thought, or that decisions are being made without coming to them that they're getting a bit aggrieved about. So having a shareholders agreement can align with minority shareholders. This list is going to go in the chat now. I'm not going to go through all of those. Just get rid of that so I can see it. All of the points, because we're going to do a few scenarios where I can pick out a few, and then when we get a bit further on, if there's anything that really you wanted to hear about, then you can put that in the chat if I've not touched on it or in enough detail. And if time permitting, I can discuss that in more detail, and then we should be able to cover them. But as you see, it's a long list. Some key things that jump out here: transfer of shares, compulsory transfer provisions, valuation, reserve matters, and permitted transfers is a nice tweak, and restrictive covenants. But there's some that I'm not going to be drawing out in the scenarios that you may want to ask now. But again, if I haven't covered something and it was something you really wanted to ask but don't want to put it in the chat, do it later, and I can have a call, or I can send an email back. So how do we go about sorting out what you might need for your company in a shareholders agreement? I do have a questionnaire, and that's something that I can send after this if you want to think about it quietly and think about it without talking to me, and then come back to me. But there's not really a one size fits all. I would say concentrate on the things that really are causing you concern, rather than thinking that you need everything from that list in your shareholders agreement. Because if you do that, you will find that the ability to make decisions and just everything's just a bit too tight. Sometimes can be good, but you don't want to have to draw on a whole list of things before you can make any decision. So we would talk about what your priorities are, what you're really concerned about, and talk about the options of that so you can discount them and make choices. What I'd like to say is that who is the client when you come to see a solicitor for a shareholders agreement? And there's, say, 3 shareholders. We would normally set the file up in the name of the company. And it would be the company or the directors, therefore, that we have the chats with, and draw up heads of terms that would set out what's been agreed at that time before going ahead and drafting the whole agreement. Because we'd really like to get shareholder buy-in to the heads of terms before we put pen to paper, because then the first draft is going to meet requirements and just make the process less painful of having to have many iterations and changes. Individual shareholders, there's a limit to what we can give advice on that point, because we can't be in conflict with the client, which is the company. And it's always open to those individual shareholders to go and seek independent legal advice and also financial advice on how the document or the share scheme or becoming a shareholder of a different class affects them. That said, it's when people are wearing the different hats, these people are normally the same, and therefore the advice can work cohesively to advise people. If we're doing with employee shares, it's probably your thought as a director that you're giving the shares or allowing the employees to have shares, and it's we'll take it or leave it kind of thing. And that's where I do see the benefit of just putting things, particular clauses in articles, because you don't have to have a discussion, you don't have to get the signature of the individual. But equally, it depends what you're wanting to tie them down to and whether you'd want the whole world seeing those things. So that's why the file is in the name of the company. But we can just act for one shareholder, but then you are dealing with lots of different parties, other shareholders and the company, to get the final document sorted out. So we would have a chat about that. So let's have some scenarios. And these give me the opportunity to go into some of those clauses in a bit more detail. So 2 friends who've started a tech business, nothing wrong with it, but they just they set up a company, and they've got equal shares, and they're both directors. But as often happens, it can be that the business isn't making enough money to support 2 directors with employment benefits and potentially the dividend that they'd both like to take out equally. Or it could be just that somebody loses a bit of interest and finds another job, or one person is really spending a lot more time on the business, but they're drawing the same dividend and basic salary in line with what their accountants advise them. But because they both have the same shares, then they, apart from one waiving their right to certain dividends, they each entitled to the same dividend. So things have started moving, honeymoon period is over, and a few problems have started which could affect the business and the decision making going along. So, assuming that they've got a shareholders agreement in place, certain provisions would have helped them, but also it gives me a chance to kind of discuss what a shareholders agreement for that type of company would benefit from having. Alphabet shares would help to award different dividends based on the time spent, if that is something that would help ease the tension in the company. It can be either that the existing shares, one person shares is reclassified as A or B or whatever you want to call them at that point, or they can keep the existing ordinary shares and we can have a lot A, B, C, just a single one, which allows the company to just declare dividends on the A, B, C shares, and it doesn't affect the original capital owning if they were not 50-50. So we can deal with it in that way. Again, I'm going to say the caveat as with accountancy, financial advisor getting involved before we put this in place, because they know what HMRC looks for, what they consider to be against the particular rules in force at that time. And that's something that we just don't want to do something and find that something that's not in our scope of work has caused problems down the line. That's why we do it with our fellow accountants. Having a director's service contract in place, which sets out who's got what role and what responsibilities, but also it may be that you're quite happy for one shareholder, director, stroke employee, them all having the same hats on, does spend less time in the business because it actually can't support that salary, that time, with a view to them coming back later. But you just need to know who's doing what and who can make what decisions. If there are just two directors in the company, then you would need them to still be involved for directors' meetings to be meaningful and proper, because a quorum, the amount of attendees to make it valid, would be two. But if there's three, then there's a bit more flexibility of involvement. But if I was a director, I'd still want to turn up to meetings, even if I wasn't wholly involved, because that's when you learn things and can have an input. And you have a duty still to know what's going on. So you can't just divest yourself of that involvement. It would potentially be helpful for there to be a dispute resolution process to help them get over the hurdles that the problems that they're experiencing, and that isn't in articles, definitely not. It could be that they can seek help from a named individual or a group, a mediation group, just before you get to deadlock position, which can really cause problems in a company, because it just stops people being able to make decisions. But these next four are really the meat of what we see in most shareholders agreements and what people want to cover. I'm going to talk about preemption rights first, actually. So this is where there's quite a lengthy clause in a shareholders agreement, but the gist of it is that if somebody wants to sell their shares, then or leave the company, then the other shareholder or shareholders are given the chance to buy those shares before they can be sold to a third party, or the shareholders agreement might actually say they can't be sold to anybody else. But you chose to be in business with that person, maybe not all so happy now, but you don't particularly want them just selling their shares to the first bidder who could be a competitor or just someone that you just didn't choose. So preemption rights are really something that aren't in articles, but allow for there to be a market for shares. And as I said, the usual process is people can offer them to each other first. If there's more than one shareholder, more than two shareholders, then it's normally pro rata, or it could be that have to be offered to A first, then B, and then C can have what's left. Or, it can be, there's quite a few options to this. But it sets out a process as a default position of if somebody wants to leave, rather than just presenting a stock transfer form that the directors have to decide whether they want to object to or not, which raises its own problems. Preemption rights provide a market for minority shareholders as well, and they also include a valuation process so that it's not a number that's dictated on the outgoing shareholder. It's or dictated by the outgoing shareholder. It's got some basis such as fair value or a formula. I always ask companies if they'd like to have a formula for their valuation, but that can be really tricky. And the multiples can change over time as to what they would get, and it can also backfire. So you have to be really careful when you're thinking about having a formula, but some companies just do lend themselves to that. Maybe an insurance company that's where the value is based on the premiums or things like that. But normally valuation is based on fair value, which requires accountants to give consideration. And the shareholders agreement would set out a few rules about that. And a key one being whether there's to be a discount for minority shareholdings or whether they are the value's done and the share or even majority shareholdings, or whether the value is done and just divided by the number of shares. So that's a consideration. I've also found that we need a definition, of valuer, but I've also found that in doing that, the standard clause says it'll be the party that an independent chartered accountant or suitable person who can value a company that the parties agree on. And if they don't agree, they will apply to the president for the time being of the Institute of Chartered Accountants of England and Wales. Great. I'm sure loads of agreements are out there with that clause in. But it's recently come to my attention that the ICAEW charged £10,000 for taking that referral on board. So we're looking again now at, is there another body that could provide that the name of a suitable independent person that's not the ICAEW, because that's just a hindrance to anything that, and I've never seen it flagged anywhere, but I'm not using that clause anymore. Certain things can come up that you could use the president of an organisation that the company's in, or if the company is a member of a chamber of commerce, then maybe the president from the chamber could be nominated. It's worthwhile giving them a ring to see if that's something that the chamber would action, but it's probably just an easy task for them just to look at local accountants and pick a name. I don't know, it depends how specific you want to be. So just a nod there to something that's changed over time. And restrictive covenants, because although it didn't say in the scenario that the individual was setting up against the tech startup, restrictive covenants can help protect the company's clients, make sure that without the consent of everybody else, a shareholder hasn't got competing interests in another company. And equally, another plus point is subject to new employment rights bill going through Parliament, where it may be in the future that the time period for employment restrictive covenants is 3 months. A shareholders agreement isn't an employment contract, and therefore the time period could be longer within reason. And always, as with restrictive covenants anyway, you do need to make sure that they're fair to withstand any scrutiny in the courts. But it's just thinking, well, actually, shareholders agreement can give me a bit more control over clients. Competingness and stopping someone earning a living is always going to be challenged for reasonableness. Now, compulsory transfer provisions. This is something that the articles certainly doesn't offer. And this is the clause that gives the other shareholders the right to buy shares from a shareholder if certain, let's call them transfer events, happen. Without this, there is no way you can force a shareholder to sell their shares. It's an add-on to the preemption process, but it's deemed to happen when those trigger events happen. And the price is always fair value, or if we get into good, bad, and early leaver provisions, there's a chance to vary that fair value with a discount. Or, subject to it being a bit challenged, just put it as £1, but that's always a tricky one. So those triggers could be death, ceasing to be a director, not attending the meetings in a certain period of time, over a certain period of time, bankruptcy, not holding an accredited a criteria for being a director, which is potentially important in certain industries where there's financial services involved, and directors need to hold certain authorities. In the world of solicitors, if it's just a law practice as a limited company, directors need to be solicitors. So if you were no longer a solicitor, then should you still hold your shares, or and can you? So those provisions allow a step for the shares of the person whose trigger affects to be on an internal market. Problem with this is you don't know when those trigger events are going to happen. And funding can sometimes be a problem. Professional firms can often get buyers, if it's like a firm of accountants, get professional loans to do shares. But other markets could be trickier to suddenly find the money. So there are two things to think about here that can be built into a shareholders agreement. But one is whether there are sufficient, whether the company could use some of its distributable profits to buy back some of the shares, and that's called a company purchase of own shares, CPOS, or company buyback. Or when it's to do with death of a shareholder, whether instead of forcing other shareholders to have to fund that purchase, whether you have shareholder protection policies and cross options in place which provide a lump sum on the death of a shareholder to be able to provide that funding, and the estate gets the money, and everyone can carry on owning the shares, except obviously with the loss of the deceased shareholder. So these are really powerful provisions that need careful consideration, but are definitely in all or most shareholder agreements that we draft. The triggers can be different. The valuation can be different. You can decide whether you want to include company buyback of shares or not, but it's that tool is hugely important. Okay. Next scenario, 50-50 ownership structure, which leads to a deadlock when the shareholders disagree on whether to expand internationally. So that would be a change of a business plan, and they would hold a meeting, directors meeting, to decide whether to do this. And two directors, we can assume, and if one says yes and the other says no, then the action just isn't taken. And that can be for any decision. Just saying one saying yes and the other saying no doesn't mean you're absolutely in deadlock. Deadlock is when the decision that isn't being able to be acted on is actually causing growth problems, intractable market problems, and just causing, as it says here, the company to be paralysed. There's no way forward, and there's seemingly no way to make that step without being in breach of being a director. So sometimes articles do include a casting vote, and I believe the model articles do. And you may, again, may not be something that you wish to happen, but so you could have a casting vote amongst the shareholder, the directors, but that can be a bit tricky. Or you could say, actually, we want to refer the problem to someone else. You can't go to the shareholders in this point in time to make the decision because they are the same people and they hold the same number of shares. So that wouldn't help. And then a shareholders agreement could include deadlock clauses to actually buy someone out. That's very draconian. There's lovely names. There's Texas shootout and Mexican standoff and things like that about who buys and who offers, and shotgun. We try not to use those because they're unlikely to be the outcome that either party want. What they want is to try and move forward in the current situation that they have, but maybe just get over that hurdle of the problem. I have to say, the scenario that we have is a pretty big one, and it may be that if it's got to such a lock at that point in time that's causing problems, then maybe it is better if someone gets bought out. But equally, you don't want that person to go, oh, I've had it, I'm just going to sell my shares to Joe Bloggs. And for the continuing shareholder to find themselves in business with somebody that they didn't want to be with, don't know at all, and then the preemption rights have a benefit. So they all kind of work together, and the shareholders agreement is a mixture of all these clauses, and they have different times that they come up trumps, really. I have stolen my own thunder in a few of this one, in that I talked about when someone dies, shares can be left in a will, and unless that's what you really want, you need to consider what's going to happen on the death of a shareholder. In a family business, this can get a bit more interesting as to what you want to happen to the founder's shares. And that's part of exit planning that accountants will help family businesses deal with, and then turn to a solicitor to help put that paperwork in place. But here they've moved two friends set up a business, and one of the founders dies, and they find that they are now in business potentially with the spouse of that person, or anybody else who's inherited the shares. So that is a key problem. And I outlined before that the compulsory buyback could allow for death to be a reason for the other shareholder to buy the shares, but funding could be a problem. Think about buyback of shares by the company at that time, but shareholder protection could be a key here. These are another cost to the company. The premiums, as I understand it, can be paid by the company, but it can get complicated if shares are held by spouses, etc. So there's limits to how useful these are, but it's always on the checklist to consider and get quotes for, because if the premium's not too expensive, which obviously is based on the health of the individuals and their age and all sorts of factors like that, it really can be useful to at least have some money, even if it's not the whole value of the shareholding, to be contributed by a life policy. The life policy providers do have standard cross-option agreements, and they need a careful read and review. And sometimes they just say that the amount that's insured is the amount that gets paid for those shares. And they are basically shared out between the surviving shareholders, and the estate gets the cash. Best practice is to make sure that the policies are always in line with the value of the company. That can get left behind, that can get too expensive depending on how well you're doing. So there can be some drafting changes to a cross option that mean that the difference in value between fair value and what comes out of the life policy can be paid over time by the shareholders to the estate and things like that. So it's a saving grace, but it's something that always needs to be reviewed annually in an annual agenda for the company to make sure that things are keeping step. So, another one. Shouldn't be surprised. This one is about how certain shareholders, you're reliant on, if the company, if you want to sell to the whole share, everybody shares to a trade sale, you're reliant on everyone agreeing. And again, you go back to the quotes we had before, we'll always agree when we want to sell, etc. But is that always going to be the case? We do like to put doubt in people's minds. It could be that a certain shareholder doesn't wish to sell because they just think, oh, we're on the edge of some growth. If we sell later, that'll get us a better price. Or I'm really still enjoying being part of this company. I don't want to just be an employee of X Limited who's going to buy the company. All sorts of personal reasons, or just belligerence, which sounds harsh, but if there has been some difficulty in everybody getting on, then it can be, well, no, I'm just going to cause a bit of trouble. That's not great if a nice offer is on the table. So we get to drag along rights, and these help where a majority of shareholders wish to accept an offer from a third party, and they say really that the rest of the shareholders are going to be forced to sell on the same terms, and we usually use a power of attorney clause in here as well that allows the directors to sign on behalf of people who are not playing ball. Without this, you couldn't force them to sell their shares. They could just dig their heels in. You think about what that threshold is quite carefully, depending on the shareholding, but also not to run roughshod over everybody. But drag along can be a magic clause if needed. Similarly, tag along helps a minority shareholder not be left behind. And if they find that a majority shareholder has agreed a nice offer for their shares, then the other people might think, I want a bit of that as well. And tag along rights ensure that they're not left behind. You don't have to have both. Certainly, most shareholders would agree drag along, but tag alongs use a bit more sparingly. But it's a good decision, good discussion to have at the time. Not a scenario, but I did want to talk about minority shareholder rights, and if on the list of checkpoint slides, this is one that is under the reserved matters, and equally it could be where I'm talking about preemption here rather than reserved matters, but I'll carry it. I think it's no, I've jumped the gun here, but I will talk about reserved matters. So ignore the slide for a moment. Reserved matters allow where a minority shareholder is just wanting to make sure that they are involved in some decisions that might have affected the value. Equally, an investor who's not got a director in place might want to have veto rights over certain decisions. So it can be framed in many different ways, i.e. such that are the reserved matters for just so that minority shareholders have to say yes to them? Are they that all shareholders have to agree before anything in a reserved matter checklist can be gone through with by a director? This is why you're binding the company. The benefit of a shareholders agreement that can bind a company and to allow certain decisions are made in a certain way, which articles can't. Investor agreements will have these kind of provisions in, which is a kind of form of a shareholders agreement, to give them the power to say, right, directors can decide this and that, but if anything's on that list in Schedule 2, then if we don't agree, you can't go ahead. So they can be really useful. But they equally, another help for minority shareholders is to have the preemption rights so that they have a market for their shares and that they don't have to rely on unfair prejudice actions if they feel that the company is being run in a manner that they're not able to control, like dividends not being paid to their class of shares, dilution of share capital and they haven't been asked about it. That can be where 1,000 more shares are allotted, and then they find that their shareholding is smaller and smaller and smaller. And sometimes directors not driving the company in the way that's for the benefit of the shareholders, which is a primary director's duty, and failing to comply with the Articles of Association. But you don't really want to get into that. In having to go to court if minority shareholders, maybe not employees, but if they are investors, they would benefit greatly from having a schedule where certain cherry-picked aspects of a company have to be passed by them. And some examples of that are termination of a director, appointment of a director, amending articles, changing the business plan or scope of the business, borrowing money in excess of usual borrowings, hiring and firing at certain levels of employee level, settling litigation, giving guarantees, changing directors' pay, issuing new shares, and entering into a substantial business contracts. Some of these points, like especially the last one, so entering into substantial business contracts, would go to directors. And as a company gets more sophisticated, it might even have a finance committee that requires other directors or a chief executive to give sign off to certain things. But in a smaller company, the limits to be placed on directors in causing a company to be bound to a contract that might be more than 2 years in length, might cause it to might be a value of a certain level, say high level, depending on how the business operates as to what's actionable there. But something that causes it to have to spend certain money or is of a certain value just might need a bit more sign off. And that can protect directors anyway, to have these provisions. So shouldn't be seen as too much of a hindrance. But, people have to remember what's in that schedule and make sure that they can abide by it, because it's no point having things in a schedule, carrying on with directors' decisions, meetings, and not looking back to see whether it's something that they should have got some more consents for. And in that situation, I'd recommend having an agenda and then a note on the back of each agenda saying what the list of reserved matters are, and for the directors to look at that list and agree that it's not, that the matters that are being decided at that meeting don't require that, because things can just get forgotten. It's human nature. Okay, so this is where you go back to that checklist, which would be in the chat box, and if there's anything that you wanted me to expand on, I can, but I do have a couple that I've not talked about that I can mention. So I'll just give you a minute. Okay, I'm going to talk about, oh, we've got one chat. Is that one? Cool. While we're finding that out, I want to talk about intellectual property clauses for a shareholders agreement. Tech companies, anything developing aspects that include new software, know-how, patents, might benefit from having an intellectual property assignment clause. It sits aside from the general law that for employees, that employees and intellectual property that's developed during the course of employment is owned and vests in, we love that kind of language, the employer, where that has been part of the employee's job description or the tasks that have been asked to do. But in a company situation, there might be somebody who is a shareholder who's not an employee but is developing really important software or know-how, or let's call it intellectual property, just to broad term, for the company, and it's not being caught by an employment contract. So you can put an intellectual property assignment clause in the shareholders agreement, and that can help you make sure that things that are invented or developed by a shareholder, whilst they're a shareholder, are assigned to the company. If you're going to have clauses like that and the power of attorney clause that I mentioned for compulsory transfer and preemption to sign things like stock transfer forms, and if someone's just not signing them, then the document would need to be signed as a deed, but that's something for lawyers to pick up and help you with. But, if your company is like that, then think about having the intellectual property clause in. And it would save you from having to have individual assignments for that. And why am I saying this? Because if you sell the company and the company's value is based on these inventions, this intellectual property, and the due diligence team of the buyer picks up and asks the question, who developed this? And they're not an employee and you haven't got an assignment, it can affect the value of your company considerably. That it may be that the shareholder who did this is no longer a shareholder and you've bought them out. But if you had the clause in the agreement before they left, then it would cover the work that they've done. It can also go further than an employment contract can, in that it could be, well, employment is things that they've done during their employment, but this would cover, there isn't employment, so it's things that they've done for the benefit of the company. I'm going to say, though, that it can be a bit too broad, and you may wish to have actually explicitly say what this includes for each shareholder. But that can be done in an addendum. Having the clause to start with helps you get off the blocks about ownership of key things straight away. So another topic is changes to shareholders and adding them to the shareholders agreement. That is possible. You would do that through a deed of addendum, and either they'd just be swapping in from the person that they've bought the shares from, or if there's a transfer of some shares and everyone's staying the same and you're add the new person. I'd say that is a good time to see whether the old shareholders agreement still works. And if it doesn't, then it might be worth the aggravation, pain of signing a new one. But if it is really just adding someone so that they're bound to the same provisions as if all those provisions were in the articles, because they've joined the gang, then a deed of addendum will work. A shareholders agreement, like a will, needs regular review. Sometimes, if on an annual review, go, that's fine, it still works. But there might just be times when you think, hang on, we've moved a lot. Let's have another look. Another nice clause to consider are permitted transfers. So, preemption rights allow there to be a process for other shareholders to be given the chance to buy some or all of the shares of somebody who wants to sell them, creating a market. That preemption right can be waived. So I say that the preemption right in a shareholders agreement is the default position. If it's not, if selling shares to a third party or giving shares to a spouse is not agreed by everybody. So let's say you could waive that and say, have a meeting saying, Mr. Smith would like to give 10 of his shares to his wife. Everyone agrees, and therefore they would waive their rights, preemption rights to those shares. And Mrs. Smith would sign a deed of addendum to be part of the agreement. Sometimes, instead of having to do that waiving business, and a shareholders agreement can have a permitted transfer clause that says that certain shareholders may transfer shares to their spouses or named groups of people or named people without having to go through the preemption rights. This isn't a clause that goes in many, but in certain setups it really works, potentially in family businesses, where you just want to be able to have that flexibility to move shares around. And you don't want to use alphabet shares, and it just needs shares need moving for other reasons. But equally, it's quite important to consider that that person is a shareholder in their own right now, so they need to be part of the shareholders agreement. But sometimes they've been given their shares as a knock-on effect of the original transferor being part of the company. And it may be the fact that the company says, well, okay, that's fine. You can give your shares to your wife and we don't need to go through preemption rights to get there. But if a transfer event like death, bankruptcy, leaving, all the things that we mentioned about compulsory transfer events affects you, the original transferor, then those shares that we allowed you to give have almost got a bit of elastic on. And when an event affects you, it affects the shares that you gave away, and they come back to be under the compulsory transfer at that point in time. And that's really important why the new person needs to sign the agreement, because they need to agree that that's the case. So we would go through that in a lot of detail if that was something that you were interested in, to make sure that it works and it's something that's going to help you. Okay, I feel like I've talked rather a lot here, and maybe the content's getting a bit dry. So I hope that in these slides, I've introduced to you that articles, where they sit, what they do and their limitations, and how a shareholders agreement can help. For accountancy listeners out there, I hope that you put this on your list to talk about with your clients when you're doing your annual accounts. See if this is something that I can chat to them about. If it's something that you wish to think about whether alphabet shares would help them, that's something quite simple for us to help with the legal paperwork about. If you are a company that's evolving and you have got an existing shareholders agreement, but things have changed or you've never had one, I hope that you now will, when faced with the questionnaire, have a bit more information about what that actually means, because there's quite a lot of concepts involved here, and we spend a lot of time explaining what they are, but hopefully that will give you a bit of a head start to take back to the company, take back to your board, to suggest that a shareholders agreement is now the time, or that you need to update one. And maybe you could lead that project and give me a call. Think about, is your paperwork up to date with the things that you need to do off Companies House, like the registers? That can be quite easily sorted. And once you have an electronic set of registers, easy to update and be kept potentially with your accountant if they do your annual returns for you, or certainly a copy at the registered office. And talk to your accountant about whether share classes could be used strategically for your business, and they'll be happy to discuss that with you and the tax consequences. Options and EMI schemes are where shares are given at a later date, but still the paperwork needs to be in place for when those employees become shareholders. So that's something we can help with. And really just remember what documents you have. Are they fit for purpose? And when you've got new ones, look at them regularly, know where they are, and make sure that they work for you and help your business grow. They shouldn't be a hindrance, and can mean that maybe you're not so worried about suddenly being in business with people that you didn't intend to be, or what would happen on death, or if someone was in breach. It's always hard to get every point out, but it's worth saying those compulsory transfer clauses are just essential if someone has breached a restrictive covenant that you've got in the shareholders agreement, because they could be setting up a competition with you but still getting a dividend and still have a chance to get a share of capital if you sold the business. And that's, you're not working for them anymore. You would find that you're working just to pay them, rather than if you were able to get those shares back, you're more in control of those aspects. So yeah, it's hard to share everything, but I hope that that's another key point to bear in mind. So we do have a few things to offer you. Shareholder checklist, which we can send to you. We are happy to review your articles and any shareholders agreement that you've got in place, have a chat with you about them and make any recommendations. So it might help you put that to the board to get the spend for doing this. Can help with any other company commercial aspects, company secretarial aspects that you're thinking of. If you just want to make sure that your filings look good at Companies House, and we can arrange for your statutory books to be reconstructed. Keep in touch for advance notice of the future seminars. There's one on the 2nd of July about exiting a business, preparing for exit, and I'd be going through the key clauses of the share and purchase agreement and asset purchase agreement, and how you can get your company ready for sale. And we're going to ask for some feedback. You can see these on the slides when you have them, but there is also some mainly employment and HR aspect free sessions coming up, which are really popular. But we're also 7th of July, there's a fundraising event for the Master Cutlers Challenge that should be fun, or will be fun, at Triple Point Brewery. That's says booking event via Eventbrite. So it'll be great food at the Triple Point Brewery, and some other fun things to do. And these HR exchange onlines really get on with key things that your business might need. But you can always keep up to date by having this QR code and get the HR and Employment Law monthly newsletters, and you'll know about all of those events online with that. Okay. I hope it's been interesting. I hope you've